Thank you so much. A hearty round of applause, absolutely. Welcome, ladies and gentlemen, to the National Constitution Center's thrilling debate on the candidates and the Constitution. I am Lester Holt. I am, in fact, Jeffrey Rosen, the president of the National Constitution Center. And here we go, which is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. How important it is to recite that inspiring mandate in these polarized times. And the Constitution Center is attempting to combat the polarization of our civil discourse by sponsoring a series of wonderful discussions about the constitutional stakes of this election. And our great We the People podcast series has held a great series of 8 episodes on what the candidates have said about each significant clause of the Constitution and how a Trump or Clinton court would differ on the significant constitutional issues of our time. And just last week in Berkeley, California, we held the first of our We the People podcasts on the road, where we had a great discussion on the same topic that you're about to hear, namely, how would a Trump and Clinton court differ across a range of constitutional issues. And that was a wonderful warm-up to today's discussion, and we're so thrilled today to bring you the live version. For those of you who need a break from the Constitution and the election, we've got a whole bunch of great town halls coming up, including on November 21st, a newly announced town hall program, Is the Constitution Judeo-Christian? That should be really provocative and excellent. And now, you know the drill, and I am so delighted to introduce our phenomenal debaters. Our moderator is the superb Tom Donnelly, Senior Fellow for Constitutional Studies, who's been such an insightful and illuminating moderator for all of these recent discussions. And we have 2 of the leading liberal and conservative constitutional commentators in America who will be debating today. John Malcolm oversees the Heritage Foundation's work to increase understanding of the Constitution and the rule of law, and he is director of the Edwin Meese III Center for Legal and Judicial Studies. And Ian Millhiser is senior fellow at the Center for American Progress. Previously, he was policy analyst for Think Progress and held the open government portfolio for the Doing What Work project at CAP. Ladies and gentlemen, please join me in welcoming John Malcolm, Ian Millhiser, and Tom Donnelly.
We have so much to cover. So obviously, we're going to focus on the constitutional visions of Hillary Clinton and Donald Trump generally. But I think the easiest way to start is that the stakes in this election for the Supreme Court are enormous. That may be one of the few things that all sides really agree on, is that the stakes for the Supreme Court itself, its future, the future of constitutional law, are very high. And so I'd like to start just exploring that idea broadly with John and Ian. And John, I'll start with you. I mean, what's interesting about Donald Trump in this context is that we actually have a pretty specific idea of the types of nominees that he would name to the Supreme Court. He released a list of names, I think 2 separate lists, one earlier and one relatively more recently. Can you talk a little bit about some of the names on that list and what it suggests about what a Trump court may look like?
Sure. First of all, it's a pleasure to be here. Thanks for having me, Ian. I'm glad to be here with you, and good to see all of you. There are 2 lists, and there are 21 names on them. Very interesting list. 20 of the people on that list are sitting judges. One of them is Mike Lee, senator from Utah, even though he has said that he's not particularly interested in the job. It's a diverse list in a number of ways. First of all, they're all very well qualified men and women. 9 of the 20 sitting judges, or I guess 9 of them altogether, including Mike Lee, clerk for Supreme Court justices themselves. They've taught at prestigious law schools. They've had other prestigious clerkships. They were distinguished private practitioners. Some were prosecutors. Some were defense attorneys. 9 of them are sitting state Supreme Court justices, which is a little bit unusual from states across the country. 2 of the other names on the list who are now federal judges were at one time state court judges before becoming federal judges. And one of the names on the list, Margaret Ryan, while she's a federal judge, is a judge on the Court of Appeals for the Armed Forces. So these are people who have a broad array of experiences that are a little bit different from your typical short list. These are people who I think will have a better sense about issues that affect the states, will have their own views about the competency of the state court judiciary, sometimes treated like the poor kid's sister by federal judges. They'll certainly pay attention to issues like federalism. It's a slightly different take than most shortlists that you see.
Interesting. Now, Ian, obviously you're a close watcher of the Supreme Court, also of the lower courts, and so you would have a sense of some of these these potential nominees. What do you make of Donald Trump's list, and what do you think it suggests about the types of folks he might nominate to the Supreme Court?
Sure. I mean, the thing that struck me the most about it is how much it didn't tell us about what he's looking for in his judges. So, I mean, it's a list of people which, as you said, John, have the conventional qualifications in terms of resume lines that you would expect to see from a person who's appointed to the Supreme Court. If I can go through a little bit of history, most of the last 80 years of American constitutional law has been defined in opposition to what happened for the 20 or 30 years before that. So in the early 20th century, an era that's commonly known as the Lochner era, the Supreme Court lost its mind and got drunk on its own power. And they started striking down child labor laws, they struck down minimum wage laws, they struck down various laws protecting the right to unionize, and then they had a big fight with President Roosevelt over whether or not we could have a New Deal, and they lost. And the consensus that emerged from that is that there have to be strict limits on the role of judges in society. And liberal constitutional scholars have spent the last 80 years struggling between two competing mandates. On the one hand, we need to have those limits because we don't want to repeat the Lochner era. On the other hand, courts clearly are supposed to do something. There's all these rights in the Constitution, and if the courts don't enforce them, no one will. And that's often a difficult puzzle to square. That I'll get into more of that when we start talking about what President Clinton might do. For the last, all but really the last 7 or 8 years of the last maybe 3 or 4 decades, there really was a consensus around the notion that democracy should be the rule and judicial intervention should be the exception. And that was a consensus. I mean, obviously we disagreed around the margins and there were some fights that got really heated, but nearly everyone, whether they were a Democrat or a Republican, agreed that in most cases, the decision about what the law should be made by elected officials and not by judges. There's a strong counter thread that's now emerging on the right to that general consensus. You saw early signs of that with the lawsuits challenging the Affordable Care Act, with the increasingly voluminous lawsuits challenging whatever President Obama does any given week. You also see some, and not everyone on the right, pushing for some very aggressive theories of the Constitution. And so when you look at Donald Trump's list, Senator Mike Lee has said quite openly that he thinks that a 1918 Supreme Court decision saying that we can't have federal child labor laws was rightly decided. That's what he believes, that the federal government cannot prohibit child labor. He's been very explicit about that. There's some other names on that list. Texas Justice Don Willett, who wrote an opinion fairly recently where he didn't go quite as far in embracing the entirety of the Lochner era doctrines, but he had some kind words for them and embraced some of the new arguments that are emerging from conservative scholars saying that maybe we should rehabilitate the way we think about Lochner. So you have people like that on Donald Trump's list. You also have people like Minnesota Justice David Strauss, who before he was a judge, was a scholar who primarily wrote about judicial restraint and why we need to constrain the Supreme Court. So what strikes me about the list is at the time that there's a minor civil war going on within the Republican Party about what the appropriate role of the judiciary should be, Trump has picked every point along the spectrum within that internal struggle. And wherever you stand, if you're a Republican on that struggle, you can find a name on that list that aligned with whatever your view happens to be about the appropriate role of judges in a democracy. That doesn't tell me very much, though, about what he will do if he's actually naming judges.
And John, what do you think about, one, that characterization of the cleavages within the conservative legal community, and two, just Ian's general characterization of Donald Trump's list?
I could actually take up the rest of this
I
hour
think
responding
that's probably true.
to what Ian just said, and we could actually have a robust discussion about Lochnerism. And I'll even, so I'll go right to the heart of what you said about Mike Lee's point. So there was a big discussion going on within the country that was certainly settled by the progressives who were put onto the court by Franklin Roosevelt about the scope of federal power. Article 1 grants legislative power, but only grants them the powers herein granted within Article 1. We were supposed to have a limited, enumerated powers. That's what the federal government was supposed to be. President Roosevelt came in and wanted to enact the New Deal, including aggressive positions with respect to economic liberties, and he tried to stack the court. Then there was the famous switch in time that saved 9, and eventually he was able to appoint the judges whom he wanted and to get the New Deal through. So when you hear a Mike Lee who was saying, oh, gee, we want to strike down laws against child labor law, it's not because he favors taking 13-year-olds and sticking them in hot sweatshops somewhere. It was a robust constitutional debate, which still lingers, about the scope of Congress to pass legislation that impinges on economic activity that takes place solely within states as opposed to commerce among the states. Now the way these laws typically come up, and actually it came up in the within the opinion that you were talking about that Don Willett wrote for the Texas Supreme Court, is these are now economic regulations, not regulating sweatshops and whatnot. It is big industries with lawyers on speed dial and regulators whom they appear before all the time, who are very, very close to elected officials, who want to crowd out competition by passing economic regulations that are onerous. The Texas case that you were talking about involves somebody who wanted to get involved in the eyebrow threading and hair braiding business. And a Texas state body made up of, surprise, surprise, entrenched barbers said, oh, no, you have to take 750 hours worth of classes before you can become a registered barber in order to do hair braiding or eyebrow threading at a grocery store. And this, under the post-Lochner era, courts will just sit there and say, well, if there's any conceivable rationale that a legislature could have used to uphold that regulation, we're going to do it. We're not even going to make them come into court and actually articulate what their reasons were. If we can fathom in our own minds some reason why they might have come up with this regulation, it will pass. And there are some judges, I think properly so, like Don Willett, who are questioning that and saying, no, this is cronyism in its worst extreme. And at the very least, you have to be able to show that the purpose for this regulation generally pertains to health, safety, and welfare and has nothing to do with just stifling competition in order to reward some crony capitalists. So there is a debate about the Lochner era. There is a debate, largely lost, about the scope of executive power and legislative power because of broad readings of things like the Commerce Clause and the taxing power. And those kinds of debates are going to be involved in terms of the next Supreme Court justice or justices.
And do you agree with Ian's take on the list itself, that it includes both what we might think of as sort of judicial restraint conservatives, but also folks who are more in this libertarian or economic rights strike?
I'm not. There's some diversity. So Ian is correct that there have been a number of conservatives, Chief Justice Roberts and Samuel Alito being most prominent among them, who have decried the Lochner decision and have said that it deserves the burial that it received back in the New Deal era. There are some sitting judges who I think are taking a look at that again. And so to that extent, there is at least Don Willett's name on that list. So if you were looking for some diversity when it comes to protecting economic liberties, there's that kind of diversity. I'm not so sure it's a Rorschach test the way that Ian quite likes it. If you like the one over there, go over there. If you like the one over there, go over there. I wouldn't characterize the list quite that way.
Okay. Well, Ian, let's turn. You could certainly respond a bit to that too, but let's also turn to what a Clinton court might look like. And I think one way to think about this is, let's fast forward 20 years.
Yep.
Hillary Clinton has won the 2016 election. She's had a chance to appoint 3 to 4 new progressive justices to the court. What are some of the issues where we might see a real transformation in constitutional law in that scenario? And I'll let you respond to that afterwards.
Sure. So, I think that, if we assume that Hillary Clinton gets maximal influence over the Supreme Court, it'll probably be less transformative than a Trump court would be. And part of that is because of the wild card of, we honestly don't know what Trump's going to do and whether he's going to pick people who are outside of any sphere of dominant thinking on how court should operate. But assuming that he picks judges that are in line with where the Republican Party is right now, I think that the Republican Party is moving more in the direction that John just described of wanting the courts to play an aggressive role in setting America's economic policy. The first sign of that was when really 5 justices signed on to most of, and 4 justices signed on to what was a very novel and new and not particularly persuasive, if you're familiar with the relevant precedents, opinion saying that the Affordable Care Act is unconstitutional. So that's the direction that the Republican Party has been moving for a while. They want a more aggressive role for the courts. I think that the Democratic Party has had a fair amount of consistency in how it's viewed the judicial role really for the last 80 years. I said before that liberals are trying to square a difficult circle, where on the one hand, we recognize courts are dangerous, and we don't want a repeat of the era when child labor laws and minimum wage laws were struck down. On the other hand, the courts are supposed to do something, and it's not always clear what the courts are supposed to do. The Constitution is a very vague document. It refers to things like the privileges or immunities of citizenship. If you know what those are, please tell me, because I don't, and neither does the Supreme Court of the United States. It refers to things like due process. So it's a very vague document, and that vagueness is often what has allowed for Lochnerism. It's allowed for judges to say, well, this has to mean something, so I'll read into it what I want. The best answer to how to square that circle was an opinion named Caroline Products, which was written in 1938. Caroline Products said that in most cases, democracy wins. So in most cases, your elected lawmakers get to write the laws. If you don't like what the laws are, your remedy is an election. Your remedy is not a lawsuit. And I think that's right. There are, however, really 2 categories of cases where there are exceptions. One is when you have an enumerated right. So the Constitution says you have a right to free speech. It's there, tells judges clearly what to do. If the government steps on your right to free speech, strike it down. The other circumstance is, and they list a bunch of examples of this, but they really all come down to when Democratic officials attack the democratic process itself. So if there's a law whose purpose is to suppress the vote, if there's a law whose purpose is to suppress debate, if there's a law that targets a disfavored group, whether it's a racial minority or some other group, and singles them out for inferior treatment, and because of that group's disadvantaged status, it is unable to fight in the ballot box to get its rights back. Those are the cases where the courts are supposed to step in. And I think that is largely consistent with the message that Hillary Clinton has touted on the trail. So if you look at the cases that she has denounced, she's denounced Citizens United because all of this money in our elections corrupts our democratic process, makes it more likely that the people who are elected will be the people who are bought, not necessarily the people that people would choose absent all that money. It also makes it so that when they get into office, they spend so much time raising money that they can't actually do their job. And so she wants to get rid of citizenship, and I think that fits perfectly within the Caroline Products framework. She wants to get rid of cases like Shelby County, which gutted the Voting Rights Act, and other decisions which make it easier for states to suppress the vote. Again, I think that fits within that framework. If you look at the cases she's praised, cases like the recent Obergefell decision, the marriage equality decision, is a classic case of a disadvantaged minority that has historically been subject to discrimination based on factors that have nothing to do with their ability to contribute to society. And so that is a case where she thinks that the courts exercised their proper role. What I think we're going to see if we have a Clinton court is we're going to see the court become very aggressive in the voting rights sphere. I don't know if they'll explicitly overrule Shelby County, but there are ways to revive the Voting Rights Act that don't necessarily require you to do so. I think that you're going to see a lot of things like this North Carolina law that took every single method that every state has come up with just to make it harder to vote and mashed it all together and passed it. You won't see that anymore if Hillary Clinton gets to appoint probably one more justice. But for the most part, I think what you're going to see from a Clinton court is you're going to see a world where if you do not like the law, you will still have a remedy. Your remedy will be to vote for someone else in the next election. And ultimately, I think that's a better world because justices and judges serve for life. And if Hillary Clinton or Donald Trump or whoever were to put a bunch of people in there who would entrench their preferred policies, then you would not have a remedy.
And so, John, thank you for that, Ian. One, what do you take, with Ian's statement of where the Clinton court may take constitutional law? To what degree do you agree with what he just said? We'll get to the Trump court in a second. And I mean, related to that, what do you think when conservatives think of a Hillary Clinton court? What are they most concerned about?
Well, other than when Ian listed the cases that Hillary Clinton wants to target in the Supreme Court's jurisprudence, I agree with him on all of those. I disagree with him on just about everything else that he said.
Okay.
So one, his comment on the first Obamacare case, NFIB versus Sebelius, there was nothing radical about the Supreme Court's ruling with respect to commerce. All the Supreme Court essentially said is you have to actually engage in commerce before you can be regulated by the Commerce Clause. And you cannot be forced by a law to engage in commerce so that then you can be regulated by the Commerce Clause. The thing that was radical was then upholding that very same law under the taxing power when Congress had very much gone out of its way to say, in as many ways as they possibly could, that this was not a tax, that this was, in fact, a penalty. And the president had said exactly the same thing. If this had ever been labeled a tax or interpreted as a tax, Obamacare would never have passed. I am also not surprised that Ian has targeted on the left's favorite footnote in all of Supreme Court literature. It's footnote 4 of the Caroline Products case that provides extra special protection for discrete and insular minorities. The Constitution doesn't say anything about that. The Constitution provides about life, liberty, and property and due process of law and equal protection for all, but the left somehow wants to set aside things like economic liberty and property rights, but they do want to focus if you're a discrete and insular minority, and to some extent the left has carried the day. I'm also amused that Ian cites the Due Process Clause and the perfidies of the right to be able to use the Due Process Clause for things like Lochnerism, when it's that very same Due Process Clause that also gave us Obergefell and same-sex marriage and Roe versus Wade and largely abortion on demand and all sorts of things. Now, with respect to where the court would go, I think that if there is a President Trump, for this first appointment, you wouldn't see the court very much change direction because you would be replacing Justice Scalia. Obviously, if there was a President Clinton, you would see an immediate impact on the Supreme Court. But I'm not going to duck your hypothetical, which is, and it's a very real It's very, very real because, look, on Inauguration Day, you not only have the Scalia vacancy, but Justice Breyer is going to be 78 years old, and Justice Kennedy is going to be 80 years old, and Justice Ruth Bader Ginsburg is going to be 83 years old. Now, I wish these people well, a long life to them, but it is an actuarial fact that on Inauguration Day, they will already have lived longer than the average lifespan of a man and women live in this country, and so the odds are high over 4 years, and certainly over 8 years, that one or all three of them will either resign or will pass on. So the next president could very, very well get to name not only the existing Scalia vacancy, but quite possibly another 2 or 3 justices on the Supreme Court, and that will change the Supreme Court for generations. Now, what kinds of cases will that court look like? And obviously, by the way, there's the flip side for Trump. So the Scalia vacancy, where you wouldn't end up seeing much of a difference. But obviously, if a President Trump got to replace Anthony Kennedy, who's been center right on most issues, except when it comes to things like gay rights, and certainly in the last term in the abortion decision, and even sort of flipped on the racial preferences decision. Fisher, too, take somebody who is a more moderate Republican, an opportunity to replace with a conservative, and clearly Ruth Bader Ginsburg and Stephen Breyer. If there were true conservative appointees on the court would go in the opposite direction what I'm about to talk about. So in terms of what cases the court would take, difficult to say in a Clinton presidency for this reason. Over the last 8 years, the federal courts of appeals have already become more liberal. So the Supreme Court will often say it's not in the business of error correction. A lot of times what it's in the business of doing is resolving splits on important questions of laws between the circuits. There are 13 federal courts of appeals in this country. On the day President Obama first took office, one of those courts of appeals, the Ninth Circuit, had a majority of democratically appointed judges. Now it's 9. And so you have a progressively more liberal lower court, and that matters. The Supreme Court hears 70 cases per year. Last year, the federal courts of appeals decided 55,000 cases. So with a more liberal lower courts, you are going to have fewer circuit splits. But in terms of the hot button issues, I agree. So Hillary Clinton has put her bullseye, as has the left, on Citizens United. They keep talking about all of this dark money. All of the money that Jeb Bush was able to raise got him absolutely nothing. Donald Trump, who has a lot of money, spent next to nothing on his own campaign, and he ended up getting the nomination. It is amazing to me that the left wants to allow flag burning, be able to go to a funeral for one of our fallen soldiers, and to protect the right to scream that the person has died because God hates gay people, but they'll First Amendment protection for Animal Crush videos. But my God, when we want to talk about money raised for pure political speech, to do something like, decide who our president ought to be, that has to go. But there are other issues. There's a religious liberty issue. Religious liberty is very much in play at the Supreme Court. You saw that in the Hobby Lobby decision. The court couldn't reach a determination last year in the Little Sisters of the Poor case. The Second Amendment is clearly in peril with the Heller decision, the McDonald decision. The death penalty is very much an issue. And of course, there are all of these voter integrity issues that Ian talked about. He calls them vote suppression. I call them voter integrity issues. There's our political divide. It is a fact that a few years ago, the Supreme Court upheld Indiana's voter ID case in the Marion versus Crawford County decision. The personnel on the court has changed since then. Justice Scalia died last February, and I believe that the lower courts have felt emboldened. And they have struck down a lot of these laws, and the Supreme Court hasn't taken these cases because they're highly likely to be evenly divided on them So certainly on those issues, the next Supreme Court justice will have an immediate impact.
And Ian, any sort of response
Sure.
to John's response to you?
Sure.
And then we'll turn affirmatively to the Trump court.
Yeah, I don't want to get too far down to the weeds because John mentioned a lot of cases, and I could give a rebuttal, and then we could wind up litigating 8 cases at the same time, and that's. But I will respond on 3 cases. So one is the voter ID case, and I think this gets to the voter ID cases, and I think this does get to a real divide between how liberals and conservatives see the proper role of the courts. So the facts on voter ID are this. There have been countless studies, countless investigations showing that, first of all, voter ID only targets one particular kind of voter fraud. It targets voter fraud at the polls. So what it is, you show up the polls, you have to show an ID, and that doesn't prevent voter absentee. It doesn't prevent absentee ballot fraud. It doesn't prevent any other kind of fraud. It prevents one thing, someone showing up at the polls, preventing them from and saying there's someone that they aren't. You are about as likely to be attacked by a fire-breathing dragon on Election Day as you are to encounter someone who commits voter fraud at the polls. And there's been numerous investigations. Iowa's Republican Secretary of State conducted a 2-year-long investigation trying to find a case of voter impersonation at the polls. He found 0 cases. In Texas, there's a big litigation going on right now about voter ID. They uncovered one prosecution, and it was a case, what it turned out to be was there was a person, I forget what his name was, it was like John Smith Jr. He was caught voting in the name of his dead father, John Smith Sr. As it turned out, what happened was he showed up at the polls. He said, "Hey, I'm John Smith," and they checked the wrong name. So voter fraud at the polls, I'm serious, like if you're afraid of unicorns, that is as realistic a fear as voter impersonation at the polls. And so the position of liberal judges has been that if you want to make it harder to vote in any way, if a state wants to make it harder to vote, they have a burden to show that the problem that they are targeting is similar in magnitude to or probably greater in magnitude, than the imposition that they are trying to that they are trying to place on people's right to vote. And since in this case, the magnitude of the problem that they're trying to solve is essentially 0. That means that there can be no justification for any a law cannot make it even marginally harder to vote because because you can't make it harder to vote for the sake of accomplishing nothing.
And Ian, before we hop, I know you have 2 more cases to go through. I just want to give John a chance to respond on the voter ID point, and then we'll move on to the other 2.
Sure. I'm not meaning to turn this debate into a voter ID debate, but first of all, voter ID is only one form of measurement, cleaning up the voter rolls for deceased members, convicted felons, non-citizens. All of these are voter integrity issues. What's more, voter ID laws, and the same thing with producing citizenship papers, not only apply to in-person fraud, they also apply to absentee ballots. And the last thing that I would say is that whenever anybody sits there and says, voter ID is a complete myth, it never happens because 1, they don't have the laws in place, and 2, once the election is over, nobody has any interest in prosecuting these cases. But setting all of that aside, voter ID is a complete myth because nobody ever gets prosecuted or convicted for these things. No cases are out there. I think it's remarkable. I mean, the left considers, for instance, and I'm not disputing this, what it is that I'm about to say. They just take it as a matter of faith that, for instance, sexual assaults are rampant on campuses. And I have a daughter who went to college. I think it's a serious problem. But if you sat there and said, how many male students are actually convicted of rape, you would find a frightfully small number. The fact of the matter is that it's an easy crime to commit. It's very difficult to catch after the fact, and particularly when you end up having a lot of prosecutors who frankly have no interest in, they would rather sweep these sorts of problems under the rug and not air any dirty laundry. But we could have a separate hour or hour and a half discussion on
We just had a traveling town
laws.
hall debate in Chicago on this issue, so yeah, absolutely. I don't know, Ian, if you want to maybe tick through the two other cases,
Sure.
then we'll turn to Donald Trump's affirmative vision.
Sure.
And
Yeah.
then we'll go to audience questions.
Yeah, I mean, I'll say briefly in response before I move on. I mean, sexual assault is actually a very different issue than voting
Sure it
rights,
is.
and it presents different challenges. I would expect that if Iowa's Secretary of State were to conduct a 2-year-long investigation of sexual assaults on campus, he'd be able to find one. So that said, so let's talk about Citizens United. Citizens United, I think, does sit at the crux of a very difficult question in First Amendment law. And the difficult question is that you have lawmakers setting the rules by which elections are run. And there's always a risk when lawmakers set the rules by which elections will run that they'll set them in a way that makes it easier for them to win. And so you have an important interest in making sure that lawmakers don't do that. That's why courts are involved in this space in the first place. On the other hand, and this is what the court said in the 1970s in a case called Buckley v. Vallejo, you have tremendous risk of corruption when you allow all this money to come into our elections. And so the courts have said that that interest in corruption is significantly weighty, that it can outweigh our fear that lawmakers will be too self-interested. And so the courts will give them more leeway to regulate in this space because we recognize that there has to be something to prevent these corruptions, and that means we have to have laws. What the court did in Citizens United, I mean, people like to talk about how it let corporations spend money. I actually think the corporate issue is a bit of a red herring when it comes to looking at what's really significant about Citizens United. What's really significant about Citizens United is it defined the word corruption in a way that's so narrow that it basically means nothing. According to Citizens United, the only thing that constitutes corruption is what's called quid pro quo corruption. So Sheldon Adelson has to go to a candidate. Sheldon Adelson is probably the biggest elections donor in the country. And he has to say, here's $1 million, and if you take this $1 million, or I'll spend this $1 million on a super PAC that supports you, and in return, I want you to vote yes on this bill. So the Roberts Court, Citizens United says that Sheldon Adelson can't do that. But that's not how corruption normally works. For, among other things, Sheldon Adelson isn't stupid, and he doesn't intend to get arrested for bribery. So what actually happened is that in the 2012 election, when again Sheldon Adelson was the largest single donor, he had 2 meetings with Governor Mitt Romney, who was the Republican Party's nominee that term. And I'm singling out Adelson because he happens to be the biggest donor. I'm sure John can name Democratic donors who have the exact same relationship.
I'll spot you George Soros and Tom Steyer.
Sure. This is not a partisan situation, but it is a situation of corruption. Now, when Romney met with Adelson, maybe they talked about their grandchildren. Who knows? I mean, we weren't there. Maybe Adelson made his money in casinos. Maybe Romney was thinking of opening a casino and wanted some advice. But I'm willing to bet they talked about policy. And I'm willing to bet that Mitt Romney was a smart enough man that he knew that the way to keep those checks flowing was to take positions on policy that align with what Sheldon Adelson wants. And that's how corruption works. You don't need a quid pro quo. I'll say one more thing about Citizens United, which this isn't necessarily a form of corruption, but I think it is an equally important countervailing reason why we need strong campaign finance laws, which is that members of Congress live in terror of the day when a super PAC swoops in and drops $3 million on their race and they don't have a war chest to counter it and they lose it. That actually doesn't happen to most members of Congress, but it's the sort of Damocles hanging over all of them. They fear it could happen, so they raise enormous war chests to prevent that from happening. If you walk out the back door of the United States Capitol and you hang a right, start to go down a hill, and on the left there'll be 2 small buildings. One belongs to the DNC, one belongs to the RNC. At the top floor of each of those is a room where you've got a bunch of desks and a bunch of phones. And what those phones are used for is sometimes for 4 hours a day, members of Congress go out the back door of the Capitol and they walk to that room and they pick up a call sheet of very wealthy people and they start dialing for dollars. Now, and this is, Democrats do this, Republicans do it, they do it because they need that war chest. Now, there may not be any actual corruption going on there. Maybe they don't change their views because of what goes on in those conversations. But if they're spending those 4 hours raising that money, they're not spending it learning about the bills they're voting on.
And let me let John hop in here. Certainly, you could respond on Citizens United or money in politics. But more generally, I'll sort of ask you the flip question I asked Ian before, which is, it's 2036. Donald Trump is won in 2016. Nominates 3 to 4 justices. Where do you see some important changes in the law, especially as we move just beyond replacing Justice Scalia to replacing the likes of Justice Kennedy, Breyer, Ginsburg?
I'll just briefly about Citizens United. One, if there is a campaign finance law that is coming out of Congress, you can bet your bottom dollar it does not disadvantage incumbents. Two, keep in mind that the Citizens United case involved an independent expenditure to make a movie criticizing Hillary Clinton. And the third thing that I would say is, we're about to have a holiday. It's called Halloween. More money will be spent by people in this country on Halloween candy and costumes than are spent by people actually electing the President of the United States. These independent expenditures allowed people like Eugene McCarthy, who couldn't find, 2 nickels to rub together, to find people who believed in him, to back him, to take on the President of the United States, LBJ, and he won that battle. So, there's, to me, when you're talking about impinging on political speech, it's nuts to me. But there you go. All right, so I do think that we had a Donald Trump presidency. Obviously, I think Citizens United would be safe. I think that we might get more rulings on what the Second Amendment means beyond the limited guidance that the Supreme Court gave in Heller. I do think that voter ID laws, what I consider to be common sense voter integrity measures, are likely to be upheld. I think the death penalty would probably be safe. There are at least 2 Supreme Court justices, now possibly 4, who have suggested that they're prepared to rule that the death penalty is unconstitutional in all of its applications, even though the death penalty is explicitly mentioned several times in the Constitution itself. The flip side of this is that I think if you had a Clinton presidency, you would see expanding legislative and executive authority at the expense of the states, which is what you saw, for instance, in the Obamacare decision. I think you would see expanding executive authority through executive orders and regulatory actions at the expense of the legislature. I think you would see expanding authority of regulators to impose and interpret laws through undue deference, which comes at both the expense of the legislatures and of the judiciary. And I think you would also see quite possibly an expansion of the authority of the courts under the guise of constitutional adjudication that impinges on the powers of the people in the states.
All right. Well, Ian, I'm going to let you respond to that, but I'm also going to bring in some great questions from the audience, so I'm going to append one of them to my...
Okay.
So one, you can obviously respond to what John said there, but here's a more general question about the power of the judiciary. In the long run, would we be better off if justices did not serve for life? And I'll let you hop in on that one too, John, once Ian's done.
I mean, it's an interesting question. I mean, there is a proposal that's been around and has been endorsed by people on the left and people on the right to create an 18-year term for Supreme Court justices. And the idea would be that they would be staggered, so one would roll off every 2 years. And so if you had a one-term president, they get to appoint 2 justices. If you had a 2-term president, they get to appoint 4 justices. And so it would bring more regularity, so you wouldn't have the situation you have right now where if a president of the wrong party is in power, a justice will hold on until they're barely able to, to think straight, and in order to keep that president from replacing them with someone different. I mean, it's an interesting proposal. I don't know that it would matter much except around the margins. I mean, if you look at from my perspective, I think that Scalia, while certainly not the justice that I admired the most on the Supreme Court, who was the longest serving Republican appointee, was certainly for most of his tenure on the court, did try to articulate a principled understanding of how the court should operate. And I think that in his later years he followed it. He was much less likely to follow it. But for most of his time on the court, he did view the law as something separate from his personal whims. And I think that one thing I find admirable about him, I think this is probably due to his experience of coming of age right after Roe v. Wade and being offended by that decision and feeling that, having the same reaction I have to Lochner, that God, we can't let courts do something like that, so I must be able to articulate limits on my own power. I think that Scalia was a very fine scholar who had a very robust vision of the limits on the judiciary. I wish he had stuck to some of the things that he said for most of his career. I think that Alito, who is the youngest conservative on the court, is not a particularly principled justice, who has not articulated a means of differentiating his personal whims from the votes that he casts. And if, in fact, there's data on this, I've looked at it some of myself. Alito is the only member of the court who has never cast a decisive vote in a way that conflicts with his own political inclinations. Every other justice on the court has done that at some point. And would I replace a Scalia with an Alito? Absolutely not. So, I don't think that shorter tenure is a panacea. I mean, I think on the margins it might be useful, but I don't see it curing many of the problems that I have with the possibility of a court running amok.
And so John,
Yeah.
1, judicial term limits. What are your feelings? 2, any responses about what Ian said about Justice Alito? And just and just finally, just to tack on one other question here. What is the future of originalism now that on the court now that Justice Scalia is no longer with us?
That's a very broad question. Great question. Look, I just disagree with you about Justice Alito. I noticed in your Twitter handle you had hater of Justice Alito. Now
I'm not a fan.
Now I see where that came from. And I disagree with you somewhat about your somehow implying that towards the end of his life that Justice Scalia was going against his principles. I mean, Justice Scalia was a very principled man. If you think that Justice Scalia, who wrote the opinion upholding the First Amendment rights of flag burners, that he was somehow a fan of flag burners, or that he was without question the biggest fan, that the most supportive of the rights of criminal defendants on the Supreme Court, bar none. If you think that he was a fan of criminal defendants who enjoyed lawlessness, then you don't know the man. With respect to term limits, I don't have a strong opinion about it. I have slight views in favor of term limits for congressmen, but even that's tempered. I can think of good arguments on the other side. Look, if I thought that there was a real problem with justices hanging on too long into their dotage when they were senile and lost more than a few miles off their fastball, I'd feel differently about it. I mean, certainly at the very end of his life, Justice Douglas, by all accounts, was non compos mentis. But for the most part, justices have shown a remarkably good ability to decide when it's time to go. And so I understand people who want to have fresh blood, new thoughts, term limits for the Supreme Court. It's not anything that I've particularly passionate in favor of or against. In terms of the future of originalism, look,
In 30 seconds or less. No.
Yeah, no, well, I'll keep it short. I mean, Justice Scalia's influence. It was a debate, really, a discussion sort of started first by Ed Meese, it's the named center in which I'm the director, and he talked about original intent, and there was sort of a friendly amendment by Justice Scalia who said, well, the intent of the framers is not so important. What is important is the original public meaning of the text and phrases and understanding of the Constitution at the time that the Constitution was framed and ratified. That is now I think it's here to stay with some qualifications. There's at least one other committed originalist still on the court, it's Clarence Thomas. Every law school now, they may only have one conservative, but they all got a conservative. They all have, an originalist. And originalism scholarship is taken seriously. And originalism arguments are done by any skilled advocate worth his salt. Talks about textualism and originalism. And even there are some liberal justices who have written vigorous dissents against, say, like the Heller decision. Even the dissents in the Heller decision, that's the Second Amendment case, attempted to ground that opinion in originalism. Now, whether it'll be around 20, 30 years from now, hard to say, but certainly the impact of originalism on the court and on lawyering and on the academy has been profound, and I expect that it will be around for a while.
Can I say a few words about originalism?
Absolutely.
Yeah, I think there's no question that lawyers and judges, at least in big constitutional cases, are more likely to make originalist arguments now than they were, say, 40 years ago. I'm not convinced that really matters. So, John, you bring up the Heller decision. And what strikes me about the Heller case is you had 5 justices who were the 5 conservative members of the court you would expect to be supportive of gun rights, who looked at the original documents and looked at the ratifying history and looked at all the originalist sources and concluded that, yes, what the framers understood the Second Amendment to mean is what conservatives think the Second Amendment means. And then you had 4 liberal justices who are the kind of people you would expect would not be particularly supportive of gun rights. And they looked at the original documents and they looked at the original history and they looked at all the sources originalists supposed to look at. And they, sure enough, the liberals decided that the original meaning of the Second Amendment is what liberals think that the Second Amendment should be. And what's appealing about originalism, Justice Scalia, this is part of what I admired about his scholarship, is he would articulate originalism as something that is important because it is an external force that constrains judges. He and I agreed on this idea that judges, that there needs to be limits on judges' discretion. And I don't think that originalism works that way. I don't think it does what it is sold as doing. And I think that Heller is evidence of that, where you can use the tools of originalism to achieve either result. When NFIB, the Affordable Care Act case, was in the courts, I used to have a blast traveling around to law schools, and I debate some conservative who was on the other side of the case, and I would have my entire presentation focus on original sources. And I would cite debates in the Constitutional Convention. I would cite statements by the framers. I would cite all of the things you would expect an originalist to say in order to build the case for why the Affordable Care Act is constitutional. And I did that, because I wanted to, because I knew that my opponent was going to try to assume the moral high ground there, so I wanted to take it from him or from her. But I also did because I knew I could. Because I knew that originalism wasn't really something that constrained the kinds of arguments that were available to me.
And John, do you want to jump in there?
Yeah, look, originalism is a mode of approaching constitutional interpretation. It doesn't mean that you're always going to agree. So even the 2 most committed originalists on the court, Clarence Thomas and Antonin Scalia, would occasionally disagree. So Clarence Thomas wrote an opinion, I think it was a concurring opinion, in which he said that anonymous speech is absolutely protected by the First Amendment. He cited the Federalist Papers, which were written under pseudonyms, and Antonin Scalia wrote a dissenting opinion in that same opinion, coming to the exact opposite conclusion. So it doesn't mean that originalism always had like a flashbulb that went off and there was the answer from on high. I do think that you can. I don't view originalism as being sort of a sham in which you can, I'll cite this over here and I'll cite this over there, and you cite this over here and I'll cite that, and they'll come up with whatever result you want. You can read the Heller decisions, they're there, and you can decide for yourself about who got originalism right. There's good originalism and there's bad originalism. It doesn't mean it always provides an answer, but it is certainly a constraining mechanism. And frankly, if you don't go to originalism, then you're just making it up.
Okay, let's go to another question. Are there other historical examples of the Supreme Court playing such a central role in a presidential election? Maybe start with Ian and then... Sure.
Well, I mean, there was a presidential election that was decided by the Supreme Court. So yeah. So there is that one.
We'll move to a second.
Yeah, I mean, like, I think it is absolutely the case that the Supreme Court has, like, we perceive it as playing more of a role in our society than we did at any point within the lifetimes of most Americans. But, like, if you want to look for a time when everything turned on the Supreme Court and was at the center of the election, look at the election in 1936. So the election in 1936, this goes back to some of how I started my remarks. Roosevelt was trying to bring the nation out of the Great Depression. The Supreme Court was the biggest thorn in his side. He in private conversations, he said to his advisors, like, I am terrified that if I can't find a way to make laws, that I'm going to be remembered the same way that James Buchanan, who left the nation to the Civil War, is remembered, because there's this great crisis, and through no fault of my own, I'm not able to solve it. He ran aggressively on the notion, the way that he put it in his second inaugural address was that the Constitution of 1787, right? I should know that if I'm here, of 1787 did not make our democracy impotent. On the other side of Roosevelt was an organization called the American Liberty League. And the American Liberty League is kind of a parody of what liberals think the Tea Party is. I mean, all of the things that, like, when we sit in our own smoke-filled rooms and joke about the Kochs were actually true about the American Liberty League. It was a bunch of rich businessmen led by the DuPonts, who were, I guess, the Koch brothers of their age, and who... It started because there was a former vice president in the DuPont company who was mad that Roosevelt's New Deal programs were lifting up wages in South Carolina, and that meant that he was no longer able to hire cheap African-American labor to work at his vacation home. And so he was mad about that, and that led him to organize this thing, and he got the DuPonts. It really was a hilarious parody of what it was. The Liberty League pushed a vision of the Constitution that was very aggressively about preventing Roosevelt from enacting the New Deal. It was about keeping the constraints on labor laws in place. It was about preventing things like Social Security from being constitutional. The Liberty League became such an enormous operation that many newspaper editorials said that it had displaced the Republican Party as the locus of opposition to the Democratic Party. And we ran an election, and Franklin Roosevelt won in a landslide. So we did have an election where the role of the Supreme Court and the role of the Constitution was on the front of what the arguments were, and the people made a pretty clear choice.
So 1936, one example. Other examples spring to mind, John?
Yeah, there are two others. I agree that the 36th election, he can characterize it how he wants to. I would say that it busted the enumerated limited powers that Congress was supposed to have through constitutional interpretation by the Supreme Court. But I agree that that election was certainly, the Supreme Court was on people's minds. Two others I would cite. Look, when Abraham Lincoln was running against Stephen Douglas, everybody was thinking about the Supreme Court's infamous decision in Dred Scott. We were on the throes of Civil War. Dred Scott was right in the center of all of that. And so that would be another election. And then one other that I would cite is that when Dwight Eisenhower, after he left the presidency, was asked whether he made any mistakes, he said yes, and they're both sitting on the Supreme Court. He was referring to Earl Warren and Bill Brennan, and certainly after the Warren courts, rather liberal interpretations in terms of the rights of criminal defendants and one man, one vote, some very unpopular decisions. When Richard Nixon was running against Hubert Humphrey, the Warren court was very much in people's minds. There'd be signs saying, impeach Earl Warren, and so that was also front and center in the election. And This one is too.
Excellent. Well, thank you so much. We're going to have to leave it there. It's 1 o'clock. John, Ian, I could have talked to you all afternoon, so thank you so much for coming. Please give them a great National Constitution Center applause. Thank you so much, John. This was terrific.
Thanks, John.
I enjoyed that.
Ian,
Thanks,
that was
Tom.
a lot of fun. Thanks so much.
Sure thing.